Hi, Nico. Many thanks for agreeing to give us an interview for our course Knowledge Management and to talking to us today about patents and the processes through which knowledge can be codified. To begin with, thanks. To begin with, I would like you to introduce yourself and tell our students a bit about what it is that you do and what your daily activities actually entail.
Yes, my name is Nico Cordes. I'm a European and Dutch patent attorney. Yeah, I work in all things related to patents. That means on a daily basis, I talk to clients about their inventions. I write patent applications for these inventions. We file them with the patent offices. I communicate with patent offices, but also all kinds of other advice. For example, whether a client might infringe upon somebody else's patent, etc.
Okay, sounds very interesting, but I would still like to know how it is that you decided to become a patent attorney. I don't know if this is a very easy trajectory to follow or if it's a childhood dream or something that you grow into time.
It is certainly not a childhood dream, but in Europe, to become a patent attorney, you have to have a technical background. And I started, I studied electrical engineering, then worked in corporate research at Philips. And as an inventor, companies often decide to file for patents for inventions done by employees. And yeah, I had quite some inventions, so I was often in contact with patent attorneys. Yeah, and at some point I became very interested in the type of work that they do. And yeah, then I took the leap and yeah, switched the profession basically from the more technical side to the patent side, but still it is a mix of legal and technical. So
And to what extent would you say that your knowledge, your technical expertise actually helps you to do your job? Is this a requirement to become a patent attorney?
Yes, it is a requirement actually, because patents are by nature related to technical inventions. So that is the very basis. So the underlying basis of becoming a patent attorney is really the technical qualification.
Okay, okay. And what would be the main kinds of expertise that you think you need in order to do this profession? You mentioned legal and technical knowledge.
Yes, legal and technical knowledge. So basically what we do on a daily basis, we combine the two. We bridge the gap between the patent system, which is very much a legal system, but the inventions themselves being technical inventions. So legal knowledge, but also technical knowledge. That is really the basis. Yeah, and on top of that, I think you have to be interested in the subject matter. So and also be prepared to, well, many of you might have read it. Patents, these are sometimes tough to read documents, so you have to have a certain affinity with that, with reading, with writing, but also ideally also with talking to clients. That is should be things you enjoy basically to do this job well.
Okay, great. This is really very insightful, and I'm sure our students are also very interested to hear more about it. So I would now like to move on to talking a bit about the form of codification of knowledge that is required when you apply for a patent, and how you do that and why it is needed. And to begin with, I would like to ask you how you actually define a patent. How should we understand it?
How should you understand a patent? Yeah, that is a good question. Basically, it is a legal construct, the patent. So it's a legal right. Actually, they call patents are an example of intellectual property rights. So they are defined by law. And a patent basically is some kind of right to have a monopoly on your invention. So basically, if you file for a patent for an invention, your patent gets granted, you and you alone have the right actually to practice what is described in the patent. Yeah, so that is a patent in a nutshell. And strangely enough, it does not give you the right yourself to practice your invention. That is what people often don't fully understand. You might think, okay, I have an invention, I apply for a patent, now I am allowed to practice my invention. But the reason that might not be is that there might be other patents already existing that also affect your invention. So often these patents can overlap. You yourself might have an invention, but you use in your invention also an invention of somebody else.
Okay, this is really very interesting, and it's something that we would like to hear about more, because it also suggests that your work as a patent attorney is also something very complex, because you need to determine whether or not the claim for that particular patent is actually is honest, whether it's actually it entitles that particular company to acquire the patent. So I was wondering, to what extent, what processes do you actually use in order to verify and to determine whether that particular company can get patent for that particular invention?
Okay, that's a good question. I think a little bit in the analogy also of a legal attorney. I'm actually not the one ultimately deciding on whether a patent should be granted. That the role is actually the patent office.
Okay.
You see the patent office in a way as a judge, basically, and I am the attorney, and I will advise the client on whether I think it is patentable or not. The reason mainly is to prevent them from additional cost, because otherwise you might apply for a patent and it will not get granted. So I can advise them, but ultimately I'm not the one deciding on that. But you're right, on a daily basis, I will typically discuss with clients whether I think this is indeed is patentable. And that that entails various things. One is, is it actually eligible to be patented? It should be a technical thing. So if it's not a technical thing, maybe you wrote a new novel, or you wrote a textbook, these things are just by law not entitled to be protected by patents. So there are different intellectual property rights for these. But there's also sometimes the entitlement. Maybe two people work together on an invention, and then the question is, well, who gets now to be owner of that patent or not? I advise them, but I'm not the ultimate judge.
And how do you actually try to figure out, when it comes to issues of entitlement, how do you determine whether more people within a company, for instance, are entitled to that patent, or can actually apply for it or have chances to get it?
Yeah, there are clear legal rules, but unfortunately, if you then apply them to the practice, then that always leaves some room for interpretation. No, I try to sort out the situation. So I ask them, okay, who was involved in the invention, who contributed which part, and then based on the legal rules that they are, then I try to indicate to them actually what the situation is. Yeah, and that could be that maybe in a university a PhD did an invention, and the professor is also mentioned on the patent application. And then in some cases, I try to delve into the issue to see whether actually the professor is a co-inventor in the sense of the law. And that might be different than, for example, on an academic paper. There needs to be a certain really tangible contribution, and I find out by discussion, basically.
Okay.
With discussing with these people.
That is very, very good to know. But hearing you speak, I also I became aware also of the fact that there are probably or surely lots of aspects of your knowledge, of the knowledge that you have as a patent attorney, that are implicit, that you take for granted. And for somebody from outside of this profession, it's not necessarily the case. So I was wondering if you can actually try to reflect a bit upon the way in which you do your job, and tell us how you see the explicit and codified aspect of a patent claim, and how you distinguish them from implicit or uncodified aspects, right?
Yeah, but you mean implicit knowledge in my role as a patent attorney?
Yes.
That might not be codified. Yes, I think patent attorneys inherent is a very clear example, I think, of a profession where many things are codified quite well by law. So there are patent treaties, and those are very well qualified. But actually, to act as a patent attorney requires much more knowledge, which is mainly, unfortunately, gained by experience.
And why that is also, unfortunately?
Because it creates maybe some kind of barrier to also enter the profession. That's also sometimes said. You cannot enter the profession by yourself. That's also by law, because the law requires you to have a mentor for at least 3 years. to supervise your work. So actually it is a mentor traineeship kind of arrangement, which is sometimes criticized in that you have some kind of barrier to entry to the profession. But having said that, because not everything is really codified, and I think also many things cannot just be learned from textbooks in that sense, you really have to practice this. It does make sense, this traineeship, this mentorship kind of concept. But yeah, much of the knowledge, and I think most of what I do in daily practice is gained by experience. So reading the legal concepts, but then also applying them in practice, and having a mentor, an experienced mentor, which then advises you.
And if we now move from this onto the claim for a patent itself or the request for a patent, very often that entails the codification of the knowledge that has actually been developed, right? Without including the tacit knowledge of the employees that have actually worked on developing that particular invention, the, how do you call the the skill for a particular approach, or why they chose particular avenues. All these embodied skills or tacit knowledge they have acquired over the years are not immediately obvious, I'm thinking, but maybe I'm wrong. So do you also have a feel for it when you're reading a patent?
Well, legally, actually, if you write a patent, you are required to describe your invention in such a way that somebody else can make it. That's a bit also a part of the concept why we have patents in the first place. It is a bit of they say a trade-off with society, a pact with society. You get a monopoly for a limited time to your invention, but in exchange, you should describe it for everybody to actually practice it or to improve upon it. So you are legally actually qualified to describe it in such a way that everybody understands it. Yeah, in practice, of course, that often is difficult because indeed, well, the core concept to really make it really work well, you require a lot of other knowledge, and that might be still in the heads of the inventors. But still, when writing a patent, it comes down to indeed asking the inventors in many stages whether this information is now sufficient to actually practice it, to really make the invention in practice. And just learning reading a patent application from somebody else might not put you in a position of actually, you might not be in the same position as the inventors originally were, because they might have much more knowledge actually.
Okay. And is it always the case that the knowledge that is actually developed or that is put into this particular invention is always developed internally by a specific company, or do you also assess or seek to provide advice to companies that are working together with other companies or with different institutions perhaps?
Yeah, that often happens. Yeah, you have often collaborations between companies. And often there are then agreements that the companies have made that if we now collaborate and an invention comes out of that, and we then apply for a patent, then they might have certain arrangements already made. That they say, okay, we both become owner of the patent, or it is only one of the companies and the other one not. Yeah, and that often happens. Yeah, and unfortunately, you have to have clear rules on that, because you can imagine in these kinds of situations, otherwise there might be a fight later or disagreements, particularly if the invention and the patent turns out to be very valuable.
And what would make such a patent very valuable?
No, well, normally if a product which incorporates the invention then becomes a commercial success. So for example, you have developed a new type of medicine, pharmaceutical, and that is a great success on the market. And, pharmaceuticals are often very easy to replicate. Well, you can analyze the composition and you can just make it. It probably does not cost much, but then the patent is the only barrier that you have to prevent somebody from actually copying it. And that makes a patent then valuable. So basically the value of a patent is determined by how eager somebody else is to do this. That is to put the product onto the market.
This is very, very interesting. So I'm now wondering, because you mentioned how easy it might be when it comes to certain products to be reproduced by others. How you actually determine when knowledge has been combined or has been applied in such a way that it can no longer be considered the property of the company that initially filed for patent. So how extensive does the combination or the recombination of certain aspects of that particular invention need to be in order to give another company the right to claim that it's a new thing or they can file their own patent?
Yeah. Actually, it is a bit in the patent system itself that if you file for a patent, or company A files for a patent, it is then after a while published.
Okay.
So other companies might then use this knowledge for pure research purposes. And if they improve upon that knowledge, they are by the patent system allowed to file their own patent. So basically, you can build, and that's I think also that is the underlying idea of the patent system, that you enable also to others build upon these concepts. Yeah, and then if somebody else improves upon that, they are the owner of this new invention. The only thing is you have to still realize that in order to practice this new invention, so to actually put a product onto the market, you might still infringe the old patent. So company A has filed a patent for a car. Well, company B sees this patent on a car and improves it.
Yeah.
So the car is now faster.
Yeah.
Then they might be allowed to file their own patent on this new improved car, and they might get that patent. But if they put this new improved car on the market, well, it is still a car, so they might still infringe the original patent. So there's often not really that much of discussion on the ownership of the new patent. Yeah, because if it qualifies as a separate patent application, then we consider it to be another invention. So they are entitled to that invention, but you still infringe the old patent.
Okay.
So these ownership discussions often don't arise if somebody improves upon something that is already then public.
And how do you distinguish between proprietary knowledge and public knowledge? Because many insights are already available. You train people through educational curricula to training. So how do you then assess what is knowledge that is public, so you cannot really lay a claim for it? And when you think, okay, this is just company specific or employee specific that works for a company?
Yeah, so the patent system says you cannot patent something that is already existing. Yeah. So if something is prior knowledge already, you cannot file for a patent anymore. Yeah, ultimately, I'm not the one to judge. It is the patent offices that will judge. But basically, we consider everything that is basically known on the internet, in books, in magazines, in newspapers, that we all consider to be public knowledge. It is only proprietary knowledge if it truly did not leave the company. And sometimes I indeed have to distinguish, and then basically I try to discuss with these people, with the inventors, whether they are convinced that it is still internal knowledge or not.
And now you talked a lot about your interactions with the inventors, with the companies, and you also mentioned at the beginning that it's important to have the right skills to develop a good relationship with them in order to get to the core of the invention they're trying to get rights over. Yeah. I was wondering if you could tell me if there are also instances when you not only verify or check to see if there are other companies that might have done something similar and then advise them against filing for a patent, but if you're also verifying the truthfulness of the claims of the company itself, right? Maybe they claim they invented something, but perhaps something in the knowledge they produced or in that invention, or that invention doesn't really work the way they claim.
Oh, yeah.
Do you also do that, or
yes, I do. No, I also do that, and I do that mainly to save the company from all the unnecessary expenses of filing a patent. For example, if they have knowledge which they actually appropriated from a student, or from some, maybe some kind of collaboration, then I advise them that maybe the actual ownership of the patent might lie somewhere else. Then they may still file for the patent, but this patent can then be later basically transferred to the original entitled owner. So I mainly advise them in a sense of try to try to be honest and open, and try to make the necessary arrangement. So if you're
Mm-hmm.
not the only owner, but somebody else is also, then try to act together. Yeah, ultimately, of course, if I really have the feeling that somebody is acting in bad faith, I will tell them
Mm-hmm.
and not
Mm-hmm.
proceed. But to be honest, that never happened so far.
Okay.
So
Okay.
far, it were only misunderstandings or people that did not fully realize how the legal situation was, and
Mm-hmm.
then just advising them then helps to straighten that out.
Mm-hmm, mm-hmm. Okay, that's very good to know. And I'm now thinking, since a lot is at stake for this company when considering whether or not to apply for a patent, how it is that you and these companies ensure that nothing leaks while you're actually evaluating their claims, to make sure that the knowledge stays within the company before you can actually start the
Yeah.
legal process.
Yeah, that is a very good question, and some companies have that internally quite well arranged. So they
Mm-hmm,
have procedures, for example, to mark documents as confidential,
mm-hmm, mm-hmm,
or to categorize them. So they have knowledge management
mm-hmm,
systems that really say, okay, this is confidential, this is not.
mm-hmm,
Some smaller companies that might not be so formal. So I will then advise them, basically
mm-hmm,
tell them, okay, this knowledge you have to keep internally until the patent application is filed.
mm-hmm, mm-hmm,
And that might mean, many cases, inventors would like to publish a paper, an academic paper
mm-hmm, mm-hmm,
on the subject. That might mean that they might have to withhold submitting the paper
yeah,
until
yeah.
the patent has been filed. And sometimes it is such that the deadline is there, and then we, on the other hand, as patent attorneys, have to hurry to quickly write the patent application to
Mm-hmm,
file it just in time before the deadline.
mm-hmm.
Yeah.
And
So
now,
basically, it is informing the company and the inventors.
mm-hmm, mm-hmm. Okay. And can you now walk us through, let's assume you actually advise these companies to go ahead. You believe that the invention they've developed actually would warrant a patent. What would be the processes to which then the company needs to go through in order to be legally provided with a patent?
Okay. We call it applying for a
Mm-hmm,
patent, and that
mm-hmm,
basically means that a patent attorney drafts a patent application based on the invention. And what we often ask the inventors is to write a technical invention disclosure, so a short manuscript, basically, preferably with as much as technical details
mm-hmm,
on the invention. And then typically I have a face-to-face discussion. Yeah,
mm-hmm.
nowadays
Yeah, via
Skype
Zoom.
to Skype discussion with them to discuss it. That I really have the feeling, okay, I technically understand it. Then I draft a patent application, so that's just really a legal document, and that often has text and it has figures. And then we typically review it to see if
Mm-hmm,
I understood everything is correct. And then at a certain moment it is filed, and from the moment it is filed, you can in principle then tell it to others without endangering your patent application.
mm-hmm, mm-hmm.
Yeah, so that is basically the process in a
And
nutshell.
And how does this affect the way the knowledge is transmitted? So the moment you have filed or you have applied for a patent, how does this
Yeah.
then affect the way in which the company starts to transmit the knowledge or to make public the fact that they believe they have developed something new that might be relevant also for others?
Yeah. What is often the case is that, for example, a company might want to tell the customers they have
Mm-hmm.
developed something. Well,
Mm-hmm.
to advertise their new product, but that means they have to hold off doing that until they have filed a patent application. Once that is done,
Mm-hmm.
well, the same day or the day after, they can actually then discuss it with their clients.
Mm-hmm. Mm-hmm.
It's very much a black and white deadline, because if you disclose it the day before the patent is filed, you are not entitled to the patent anymore because it has
Mm-hmm.
become public. So they have to keep it secret until the day
Okay.
of filing of the patent application.
Okay, and the people assessing or approving or granting them patent would be people like you, or do you need to have another type of expertise in
A
order
similar background, so also a technical background and a legal
Mhm.
background, but they are called patent examiners.
Okay.
And
Mhm.
they have a little bit the opposite role. So they basically, instead of drafting patent
Mhm.
application, instead of acting on behalf of the client, they act on behalf of a governmental institution
Mhm.
or an intra-governmental institution, and they basically see if the patent it qualifies for a patent, whether all the if it's really an invention, basically, these kinds of things, and whether it was not earlier published. So they will actually then search for prior art and to see, okay, has it been published before by somebody? In which case you're not entitled to the patent.
Now that you mentioned this, and I know you referred to it a bit earlier when we were discussing some of the advantages, I'm also thinking if there are other situations when it would not be beneficial for companies to consider applying for a patent. So even leaving aside the legal costs or the time that it will be taking, whether there's a moment when even though they may have invented something that is new, it might be worth the while for them to just share it with the world without trying to privatize that knowledge.
There might be ethical considerations. So you could think of institutions that are funded by public money. Universities. There are arguments to be made that if it's funded by public money, then everybody should allow the fruits of that investment to be used by everybody. So there were discussions whether universities should file for patents. And in some cases you could argue that might not be. Maybe you should not do that. On the other hand, an argument is also often to be made that just filing for the patent does not mean that you prevent others from.
And whether or not they should apply for patents, since the knowledge they're public institutions. And I know one of the way they tend to do that in some technical universities by creating startups that are somehow attached to the universities that can then apply for a patent.
In principle, universities. Sorry.
No, go ahead.
Universities are in principle also allowed to apply for patents, and they often do. And you could think of ethical considerations. Should a university, which is a publicly funded institution, apply for patents? Create a monopoly. But you could also have the other reasoning that by having a patent, it does not necessarily mean that you forbid others from practicing, because you can also still, even if you have a patent, you can grant other parties the license, or you just can say everybody can do it, and we will not use our patent. So having a patent does not mean that you necessarily have to use it. And that's often, I think, done by universities, in that they say, okay, we file for the patent as a kind of precautionary measure. And also you could think of universities filing for patents in other jurisdictions. So European universities filing for the patent in the US. You might say, okay, maybe in the US they have a bit of a patent right because they were the first to come up with the invention, and they were not funded by US public money. These considerations can be made.
Okay, this is very interesting. And are then patents the only ways in which knowledge can be privatized by public institutions, or is there any other way in which they can lay claims that some inventions or forms of knowledge are private?
I think by nature, much of what universities do is meant to be shared and to build upon. So you lay foundations on which another person can then do something. So I think, of course, in academia, there's a claim to fame if you're the first to publish it, and all these kinds of scientific metrics. I think that in practice also plays a big role. But fundamentally, once you published it and you did not apply for a patent, and you don't have other means of intellectual property rights which apply, then in principle, our economic system now says you are allowed to copy it.
And now in your answer, you already alluded to aspects that seem to me or suggest to me that trust is very important in this process. And I was wondering to what extent does the application for patents and perhaps the acquisition of a patent actually leads to more trust between different companies, or between companies and the employees that have worked for a particular invention, or companies in society, and whether it actually makes relations a bit more tense or conflictual because we need to have this legal mechanism in place to make sure that we stick to our own territory.
Normally, I would say it makes communication or the collaboration between parties actually easier. Because the alternative, if you would not have a patent, then the economic realities are that you would be allowed to easily copy something. And in our economic system, other companies would do that. So that would create the natural tendencies for companies to keep all the knowledge internal. Yeah, to not share it with other parties. Because if you share it, what will come out of it? Well, there might come out good things, but it might be also that somebody else simply copies your idea and runs off with it. So I would think that without patents, that in many cases that would make companies much more secretive, and perhaps even internally secretive. So some companies might then be very much so an invention done in one part of the company would not be told to another part of the company, just out of the precaution that somehow it might escape the company. So by having clear arrangements on patents, actually that makes it possible to collaborate, to talk to each other. Yeah, say, okay, whatever comes out of this, we jointly get now the patent. That might encourage people to more freely stimulate and share the knowledge. Yeah, of course, there's also another world in which we say, okay, we do not care at all if somebody else copies our idea. And then, of course, you could also freely discuss a concept and you would not need to worry about patents. But I think that just mismatches the economic reality that we have.
And you touched now, I mean, the entire interview, we discussed knowledge and expertise in various ways. And I was now thinking of your claims or the way in which you relate to knowledge, to the knowledge these companies have, to how knowledge might be shared or not, depending on trust or the lack of trust between different departments in a company. How do you then approach knowledge? Is knowledge then a resource, something that you can store in a repository, or is knowledge something that only becomes manifest in practice, in the way in which people do certain things, in how they evaluate certain things, or is it something that comes together as a result of an interaction, right? You will have multiple people coming together, sharing their insights, using particular tools, and the result would be something we call knowledge.
Yeah, that is a good question. Maybe in practice, if you talk about the knowledge behind an invention, what I see is that it in many cases comes from collaboration. So most of the successful inventions are actually coming from collaboration between different people. So it is seldom that there's a very sole inventor. And in many practice, a successful invention is one that is actually put to practice. So somebody built a prototype internally or developed the pharmaceutical and tested it. And that kind of thing often involves more than just the written documentation. So often, if you come up with an idea, so you have an invention, then actually putting it to practice involves all kinds of considerations, a bit the Fingerspitzengefühl that you mentioned earlier, that actually then really make the invention. Because in practice, in real life, it might often work a little bit differently than the original idea.
And can you train for such collaborations in your experience?
Sorry?
Can you train for such collaborations that would lead to this one prototype, or can you prepare, or is it serendipity playing a role in?
Well, I think with just as with entrepreneurs, you have serial entrepreneurs that are very successful in starting one company after the other. I do recognize sometimes that you also have serial inventors. And what you often see is that these are not the people stuck in the lab somewhere in an isolated room, but those are the people that actually very much collaborate within the company, and maybe also with various other disciplines that you did not think of. Because actually most of the inventions are done by combining knowledge from two different disciplines together. That is then often the surprising thing.
Yeah.
The most successful inventions actually come from that.
Okay, this is very interesting, because it also implies that people manage to develop a common language, right? Because even in technical fields, you do have people who specialize in different areas. Do you think they already have this lingua franca in order to understand what each one of them is doing, or do you need to be curious or have the time and effort to invest into learning how mechanical engineers, for instance, do certain things, and you as an electronic person or some other type of engineer need to understand how they go about it in order to develop this new prototype?
I personally think that is just a basis behind not necessarily being a good inventor, but just also being a good scientist or engineer, to have an open mind and curiosity for other disciplines. And indeed, there are many examples, I think, where, for example, inspiration is derived from the biological field. And then is used to improve airplane wings or something like that. So I think in the scientific community is quite a bit recognized already that you have to have this open curiosity. And I know that some companies also stimulate that internally. So they stimulate these cross-boundary collaborations, if it's possible within a company, if the company has indeed different disciplines. On the other hand, there are even companies that specifically try to come up with inventions by combining these different disciplines. But sometimes I find it a bit of a brute force way of approaching inventions. I think typically the best inventions come naturally if you collaborate as a result of the collaboration. But yeah, whether I think there's some kind of common language, the further away the disciplines are, perhaps the less they there might be. But but people.
This seems to be like a great note to put an end to our interview. The idea that you need to be curious, to have an open mind, and to try to collaborate with people in order to develop new knowledge. So I'm very grateful that you made the time to talk to us about it. And perhaps one last thing that I might add, or another final question I might have, is to what extent do you see standards changing in the way in which new types of knowledge are assessed? I don't know if patents or the application for a patent was done differently in the 1970s, or if you use different standards now because of the digital age, because there are different risks for leakage, or for companies to actually use that knowledge faster, and then you would be put out of business, or you would be actually hit by
I think many things are changing. So the pace seems to be much faster. So both in companies and trying to beat the competition, I think there's a much faster pace. That means also the patent timing is quite strict, so we try to do it as fast as possible once an invention has been applied for.
But you don't notice any difference in the ways in which knowledge is assessed, or how that invention proper is assessed, or you do?
Okay, the assessment itself, so the criteria on when it's eligible for a patent. In principle, the legal framework has remained surprisingly unchanged. That is true, but you see the framework struggling a little bit with new developments. For example, artificial intelligence. There's now a very fundamental discussion whether AI is entitled for patents, because the legal framework says it's only people that can be the owner of a patent. So this is very much in discussion right now, whether an AI can actually come up with an invention, and then
This is amazing. So you're actually leaving us with a tremendous amount of food for thought. I'm sure our students will be very interested now in looking into patents, and also probably lots of debate will be generated among them whether or not AI is entitled to make such claims. So we're very grateful for making the time for this interview, Nico. Thanks a lot.
Yeah, you're welcome. Glad to be here.